New York has one of the most tenant-protective late fee frameworks in the country, shaped by decades of tenant advocacy, recent legislative reforms, and a complex overlay of state law and local regulations. The governing law is found in the New York Real Property Law, the Housing Stability and Tenant Protection Act of 2019, and, for New York City, the Rent Stabilization Code and local housing regulations. If you're a landlord or tenant in New York, the late fee rules are specific, and the consequences of overcharging are serious. Let's start with the statewide framework. Under the Housing Stability and Tenant Protection Act of 2019, New York imposed a statewide cap on late fees. The late fee cannot exceed $50 or 5% of the monthly rent, whichever is less. This is critical. Whichever is less, not whichever is greater. This means the $50 cap applies to any rent above $1,000 per month, because 5% of anything above $1,000 exceeds $50. In New York City, where average rents are well above $1,000, the $50 cap effectively controls for the vast majority of rentals. On a $2,000 rent, the maximum late fee is $50. Not $100. On a $3,000 rent, it's still $50. The 5% calculation only matters for rents below $1,000, where 5% produces a number below $50. This flat $50 cap on the high end is one of the most restrictive in the country. For landlords in expensive markets, Manhattan, Brooklyn, much of Queens, the $50 maximum fee on a rent that could be $3,000, $4,000, or $5,000 is a very small percentage of the monthly obligation. New York mandates a grace period. Under the Real Property Law, the tenant must be given a grace period of 5 days before any late fee can be imposed. If rent is due on the 1st, the late fee cannot be charged until the 7th. The 5-day grace period is mandatory. The lease cannot shorten it. The lease must clearly state the late fee terms. The fee amount, the grace period, and when the fee applies must be documented in the rental agreement. A late fee that isn't specified in the lease is not enforceable. The 2019 reforms strengthened the disclosure requirements. Landlords must be transparent about all fees. New York law prohibits compounding late fees. The landlord cannot charge daily or weekly penalties for continued non-payment of the same month's rent. One fee per late payment, capped at $50 or 5% of rent, whichever is less. No escalation, no accumulation, no additional charges. The 2019 Housing Stability and Tenant Protection Act fundamentally changed the late fee landscape for rent-stabilized apartments, which represent a massive portion of New York City's housing stock. For rent-stabilized units, the late fee cap applies to the stabilized rent, not any theoretical market rate. Landlords of rent-stabilized units must calculate the cap based on the actual legal regulated rent. The interaction between late fees and the eviction process in New York is heavily regulated, particularly after the 2019 reforms. New York requires landlords to provide specific predicate notices before commencing eviction proceedings. The amount demanded must be accurate and must include only legally compliant late fees. For non-payment proceedings in New York, the landlord must serve a written demand for rent, and the demand must accurately state the amount owed, including non-compliant late fees, fees that exceed the cap, that were charged before the grace period expired, or that include compounding charges, can create defenses for the tenant and delay the proceeding. New York's eviction process is one of the longest in the country, often taking months from the initial notice through the court proceedings. During this extended timeline, late fees accumulate, but each month's fee is independently capped at $50 or 5%, whichever is less. Over 6 months of non-payment, the total late fee accumulation is still only $300 at most, even on a $3,000 rent. New York City's Housing Court handles residential eviction proceedings. Housing court judges are experienced with late fee disputes and will scrutinize the landlord's calculations. Non-compliant fees are struck from the demand, and repeated non-compliance can undermine the landlord's credibility with the court. For rent-stabilized tenants, the Division of Housing and Community Renewal oversees compliance with the Rent Stabilization Code. Excessive late fees on stabilized units can result in complaints to DHCR and enforcement proceedings. New York City's Right to Counsel law provides free legal representation to income-eligible tenants in eviction proceedings in certain zip codes, and the program has expanded over time. Tenants with attorneys are far more likely to challenge late fee calculations. Landlords in New York City should assume that their fee calculations will be scrutinized by a tenant's attorney. The security deposit rules interact directly with late fees. New York limits the security deposit to 1 month's rent under the 2019 reforms. The deposit must be returned within 14 days. Unpaid late fees that comply with the cap can be deducted, but the deduction must be itemized. Deducting non-compliant fees from an already limited 1-month deposit creates significant liability. The 2019 reforms also require landlords to hold deposits in interest-bearing accounts and provide annual interest payments to tenants, or allow tenants to apply the interest to rent. This detailed deposit framework means that every dollar deducted from the deposit is subject to scrutiny, including late fee deductions. For tenants receiving Housing Choice Voucher Assistance, which is common in New York City, landlords cannot charge late fees when the housing authority's portion is delayed. New York City and New York State both prohibit source of income discrimination, meaning landlords cannot discriminate against voucher holders. Penalizing a voucher tenant for the authority's processing delay creates both a late fee violation and a potential discrimination claim. New York City's Department of Housing Preservation and Development, the Tenant Protection Unit, and various tenant advocacy organizations, including the Met Council on Housing and Legal Aid Society, actively assist tenants with late fee disputes. The enforcement infrastructure is robust and well-funded. From a practical standpoint, the $50 cap fundamentally changes the late fee calculation in New York's expensive markets. In Manhattan, where rents commonly range from $3,000 to $5,000 for a one-bedroom, a $50 late fee represents roughly 1 to 2% of the monthly rent. This is far too small to function as a meaningful behavioral incentive. Manhattan landlords should not rely on late fees as a tool for encouraging on-time payment. Screening for financially reliable tenants is the only effective strategy. In Brooklyn and Queens, where rents range from $2,000 to $3,500, the $50 cap produces similarly minimal fees. The behavioral impact is negligible. In the outer boroughs, parts of the Bronx and Staten Island, and in upstate markets where rents are lower, the 5% calculation may produce a number below 50, in which case the lower amount controls. On an $800 rent in Syracuse, the maximum fee is $40. Upstate markets, Buffalo, Rochester, Syracuse, Albany, have more affordable rents where the 5% cap may actually be the binding constraint. A $1,000 Buffalo rent produces a $50 maximum. A $700 rent produces $35. The Hudson Valley, Westchester, Rockland, Orange, Dutchess, has expensive suburban rents where the $50 cap applies. Landlords in these communities face the same dynamic as New York City. The fee is too small to matter on a $2,500 rent. College towns, Ithaca, New Paltz, Binghamton, Stony Brook, have student markets where financial aid timing affects payment patterns. The 5-day grace period covers most processing delays. The $50 cap means the fee itself is modest. One best practice for New York landlords: accept that the $50 cap makes late fees a nominal administrative recovery, not a revenue source or behavioral tool. Set the fee at the statutory maximum, $50 or 5%, whichever is less. Document the 5-day grace period, and focus your actual late payment strategy on screening, communication, and efficient eviction procedures when necessary. Another best practice: never charge more than the statutory cap. In a state where tenants increasingly have access to legal counsel, through right to counsel and legal aid organizations, Any overcharge will be identified and challenged. The risk of charging $55 instead of $50 is not worth the $5. A third best practice: keep separate late fee tracking for each unit and each month. New York's extended eviction timeline means that disputes may involve months of accumulated fees. Each month's fee must independently comply with the cap. Your records should show, for every late payment, the rent amount, date due, date paid, grace period expiration, and the fee charged. This documentation must be airtight for housing court. For the complete guide to New York late fee laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our late fee law series.